Good evening, welcome to my YouTube channel. Today we are talking about work. We are continuing from where we left previously about 1 to 2 weeks ago. I took time off to take a reflection on many things, and then we are continuing now. If you watch this video, watch with the rest of the videos. Thanks everybody who have been supporting me, watching the videos, sharing the videos with family and friends, and also clicking like, clicking notification bell, subscribing, leaving a comment below, having a conversation. Thank you so much. We are talking about work in the UK, and I've already said elsewhere in the video that what happened in the United Kingdom is important because it is similar or perhaps also the same with what happened in Europe, America, and the rest of the continent of Asia and Africa. Leave a comment below if you know anything about work. Is the primary source in the modern economy of income. There are other sources of income such as loan, grants, and leave a comment if you know anything about income, which is a form of financing. And employment can be seen in that light as an economic factor, but it can also be understood as a social factor. And today, if you look around in the United Kingdom and also around the globe, there is something called privatization, which actually promote private businesses in the small and medium and the corporate sectors. Corporation simply means something is huge, it's big, it's very wealthy. And in the current atmosphere of the modern economies, small and medium businesses are closing down, and big corporations will eventually close down, maybe within the next 100, 500, maybe 1,000 years. There will be an end to the economic age as we know it. That means technology, we are entering into technological age, which will run the economy in terms of work. So these machines, this technology system will take over running the economy and also running the world. The government, as we understand it, is also closing down. Increasingly, if you in the UK you visit supermarket, you will notice a lot of changes at the checkout, where the cashier used to be predominantly now is self-service because of the machine. Computerized systems, nanotechnology, robotics is coming. 3D printers, artificial intelligence. I keep mentioning this is actually the fingerprinting of modern technology as we understand the world today. Leave a comment below if you're a technician. The future of society, even in currency, is extremely exciting, and that's why I'm looking at employment, because there will be mass unemployment going forward. The machine will be doing everything going forward. Beginning now, there's going to be less and less work going forward from now. So ordinary people, the likes of you, yourself and myself, will more and more be outside of work. People will be doing other things, hopefully for the better, if we use peace to run our country. What we have seen in parts of the world, in Africa, maybe in Kenya, in part of the world, if we avoid violence, if we use our culture to work peacefully as governments, as civil societies, and also if there is military to function to protect society in one way or the other, or the police, they will be functioning within the cultural system of peace. as opposed to what we now see. The greatest threat to society is actually violence, war, and all the conflict, all the injustices, the evil is the primary source of problem in the world. And talking about employment as a continuation of the topics I've been engaging in on this program. And so today we are going to look at specific going forward. Leave a comment below and let me know what you are thinking are. Today we are looking at something called a variation of employees' contracts when the company is insolvent. Insolvency in terms of operations, or also entity, maybe also, let's say, concerns, regardless which terminology you use. These are actual operations which may cease to exist, maybe shutting down for one reason or another. Maybe we experienced during COVID-19 when organizations, small and medium business in particular, are closing down anyway. It's a process of change in many ways, but there are also a lot of cataclysm. If I pronounce that word correctly, a lot of crises, if you like, happening to a company, the system of capitalism, which I mentioned previously, including the cost of living crisis, which is a feature of crisis, sets of crisis which accompanies modern society, economically at least. But employment is quite a factor of economy, like I said, and also a factor of society, because it is the primary source of welfare. If you work and earn a living, then you are surviving adequately, or otherwise, if you are paid badly or you're paid well, then that is something you can take on board to continue living your life in a relatively peaceful and understandable way. So let's talk about this material and looking at it in fair detail. If you are in the United Kingdom, if you are not in the United Kingdom, regardless where or who or what you're doing, in the end, work is work. Employment, as we talk about, is a type of status of work in the United Kingdom, in the legal sense of the word. In the strictest sense of the word, is employment is actually a factor of work. If you like, as a system of law and policy in the United Kingdom. And within employment, we have contracts which govern a relationship between particularly between employee and an employer, but it can also govern relationship between different factors of work, of industry, of employment, the employment sector, between customers. Some customers are also employee, or some bosses are also customer, and vice versa. So these are the nitty-gritty. There's the little pieces of material which we're going through, like I did in the previous time. Bear with me. They are fairly thick, so I try to normalize it as much as I can so that it is usable within this framework. So in order to improve the chances of insolvent businesses being able to survive insolvency, the two regulation, this is to do with the European Union as a factor of regulation which actually protects certain rights within the employment law in Europe, and also particularly in the United Kingdom. So we are talking about the two regulations introducing special rules allowing employees' contract to be varied, where the business insolvent, varying employment relationship means making changes either in one way or the other, either with or without consent. And these are some of the issues. If you are dealing with employment issue at law, you try to pay attention to the rules on variations of contracts set out in earlier in this advice document. Do not apply where the business is insolvent. So if the business shut down, the rules on variation as to contract necessarily does not apply. So from the 6th of April 2006, where business is insolvent, the regulations allow the transferor, transferee, and any insolvent practitioner to reduce pay and introduce in other inferior terms and conditions. The changes to the terms and conditions must, however, be agreed with the representatives of the employees as a permitted variation. You can look further for more information at gov.uk, which also produces this material for guidance to the public. Is freely available online. The other sources of information online as well. You can actually look to check. In the modern society, you have to be an author of your life. We live in the knowledge economy, so empowerment begins with information and knowledge. Self-learning is the name of the game, is the order of the day. So let us carry on to look at permitted variation to contracts. Watch this video and the rest of the videos for this to make sense. Thank you so much. So the main or the principal reason for the change to the contract must be the transfer itself, or a reason connected with the transfer which is not an ETO reason. The change to the contract must also be made with the intention of safeguarding employment opportunities by ensuring the survival of the business or undertaking. So the other conditions would include factors including the transferor, and the transferee or insolvency practitioner must agree. The changes to the contract with the representatives of the employees. You can look at a solicitor, might be a lawyer or an advisor who represent an employee, or their counselor or advisors. So the rules concerning these representatives are much the same as applies in the context of the consultation and exchange of information rules. Stay tuned, continue watching. The representatives must be the trade union representatives where they are recognized for collective bargaining purposes. So in this example, we're talking of representative being the trade union representation, and also therefore where no recognized trade union representatives are present. Other elected non-union representatives may agree the permitted variation on behalf of the workforce, provided that the agreement is in writing and signed by the representatives, and the employer first issues copies of the agreement to all the affected employees with any guidance that may be needed to understand the agreement. You see, the environment of employee relationship can be arbitrary, because these parties are free to enter into contract, and sometimes you need some form of accountability or some representation or democratizing of the factor to inject in some element of regulation. That's why you hear of representative being elected or being electable as such to be acceptable in terms of representative. We are talking broadly about dispute in employment systems and relationship in the United Kingdom. Stay tuned, continue watching.
Some see the original, mighty the god, the magical radical. Hey, representing my magical, young Jose come milli. Yanda me go wacha, yal defta, kina teach me kenyo la me go kopa. Yal wacha, kina dame chini kenyo la me go wacha. Yal defta, kina teach me kenyo la me go kopa. Yal defta, kina dame chini kenyo. Gangsta de kamele mele, deya, eja kaman deya, we are there for the bed. We have a day, you're my baby. Every day I call you, my door, you're my treasure. Baby, got no machina, yo. Baby, quackana, yo. When it's over to Koda, baby, got the machina. Baby, got your quara. You must say bandana. You must say bandana. You must say bandana. Baby, got no.
So as I say, there are permitted variation which must not breach other statutory entitlements. For example, any change to reduce the employees' wages must not take their wages below the national minimum wage National minimum wage is a statutorily enshrined right of employment or pay how much an employee or similar entity should be treated in terms of employment, and in the minimum sense of the word. Leave a comment below if you know what minimum wage, national minimum wage is. If there are no representatives at the workplace and none are subsequently elected, it seems that a permitted variation may not be made. So let us look at occupational pension schemes. From the 6th of April 2005, an employee taking on employees under a transfer of undertaking where the transfer regulations apply will be required to offer those employees a minimum level of pension protection if the employees had access to any type of occupation pension with their former employer. This includes employees who were members of the former employer's pension scheme. There are things within employment known as pension scheme which provide pension being a type of income at retirement or at retirement age, and when you is a type of benefit in the United Kingdom, which is quite similar to modern economies across the globe. And therefore, employees eligible to be members of the former employer's pension scheme but who are not yet joined the scheme. These are details. Employees employed by the former employer who are in a waiting period before becoming eligible to join the former employer's pension scheme. We'll talk about transference of rights and obligations from one employer to another during a situation where entities shuts down, like we mentioned in the opening of this process. Thank you so much. So you can look in detail, fair detail, more about occupational pension and transfer of undertakings. So when we talk about undertakings, we mean organization or businesses in the contractual context of the word. So look at something called auto enrollment, which means auto means what it is. It means there is a sense of automation in the process. Enrollment is what it is also. So where the new employer is already under a duty to auto enroll, they will automatically enroll. They will have to automatically enroll all eligible transferring staff. So we talk about eligibility if you are actually allowed or you are entitled to certain benefits or certain rights. We'll talk about eligibility in that sense. So let us also look at dismissals and TUP. So if an employee is dismissed by either their old employer, the transferor, or their new employer, the transferee, the dismissal will fall into one of four categories. Stay tuned, continue watching. The only or main reason for the dismissal is because of the transferor. This is one of the situations. If that is the situation there, the only or main reason is a reason connected with the transferor, with the transfer that is not an economic, technical, or organizational reason entailing changes in the workforce, or reason. Economic, technological, and organizational reason. I think that's what it means. So dismissal is for some reason other than the transfer, but it's for an or reason. Watch this video and the rest of the videos because this is discussed in fair detail in the previous materials. So the regulations say that where the dismissal is for a reason connected with the transfer, the dismissal is automatically unfair. So let us talk about unfairness and in unfairness in the other video as a concept of law in employment, within the employment law. So unless the dismissal was for an economic, technical, or organizational, which is or reason which necessitated a change in the workforce, this is some of the exception to the rule under these scenarios. This means that if the dismissal is for an ET or reason, it is not automatically unfair. It may still be ordinarily unfair, however, depending on the reason for the dismissal and whether the employer has followed proper procedures in dismissing the employee. So these are content involving detailed specificity, and it's of interest. Stay tuned, continue watching, leave a comment below, let me know what you think. So the employee can, however, only claim automatic unfair dismissal if they have worked for the business for the qualifying period. We have talked of qualifying period before. This is a very complex area of law, and if you are in such a situation in this case, you should be referred to a specialist employment advisor. So as you can see, there is always help when you are looking. So economic, technical, and organizational reason, ETO reason. Let us look at that in fair details. The exception to the protection against dismissal when a business is transferred is where an employer can show that a dismissal was caused by an economic, technical, or organizational ETO reason entailing changes in the workforce. An employer, either a transferor or a transferee, can defend a claim for automatic unfair dismissal by claiming that the reason for the dismissal was not the transfer itself, but an ETO reason connected with it. The difference between the two is not always obvious, and each case will be decided on its own arguments. Stay tuned, continue watching. There is no statutory definition of an ETO reason, but it is likely to include a reason related to the probability, profitability, or market performance of the transferee's business, an economic reason, therefore. So genuine redundancies which are nothing to do with the transfer can constitute an economic reason. Also, a reason relating to the nature of the equipment or production process which the transferee operates, a technical reason. So you have a lack of appropriate skills in the workforce or inability to adapt to a new method of working. These may constitute a technical reason. So a reason relating to the management or organizational structure of the transferee's business, an organizational reason. A reduced combined workforce may give rise to an organizational reason. Look at changes in the workforce. So an employer may try to argue that the changes to the terms and conditions of employees are so great that they amount to an ETO reason entailing changes in the workforce. The Court of Appeal has said that a change in terms and conditions of employment was not an economic, technical, or organizational ETO reason in of itself because the wordings are entailing changes in the workforce meant that there must be some reason for the employer needing to make the changes. In this case, the quarry man had been dismissed because he refused to accept a lower rate of pay after the business was transferred. The new employer wanted the standardize the quarry man's rate of pay with the employees. The Court of Appeal said that it did not think that the dismissal of one employee followed by the engagement of another in this place constitutes a change in the workforce. It is only when the employer sets out to change the structure of the workforce by reducing the number of employees or changing their functions that the reason will entail a change in the workforce. In another case, the Employment Tribunal appeal held that harmonization of terms after a transfer, which does not involve any reduction in the number of employees or any change in their functions, is not an ETO reason justifying a change in terms and conditions. Any resulting dismissal was therefore unfair. If an employee is claiming unfair dismissal and the employer is using an ETO reason as a defense, it will be useful for the employee to quote the Berryman case and try to show that the workforce has not substantially changed since the transfer. If the employee can show that there has been no significant changes in the workforce since the transfer, then the employer's case will fail. When looking at the change in the workforce, it will be necessary to look at both the numbers of employees and the function they perform, both before and after the transfer. The employee needs to check whether the numbers employed are about the same and whether the employees are doing roughly the same work or the same tasks. An employer cannot argue that deliberately refusing to take on transferring employees is a valid ET reason. So the reason for the changes must be connected with the future of the business's ongoing concern. So a requirement that the purchaser was only willing to acquire the undertaking without employees was not sufficient to amount to an ETO reason, and a TUB did therefore apply. The onus lies on the employer to show that a dismissal is for a genuine ETO reason, and that the dismissal is therefore fair and on these grounds. Thank you so much. Continue watching. Stay tuned. So let us look at the change of workplace in England, Wales and Scotland from the 31st of January 2014. Wales and Scotland changes in the workplace specifically include a change of workplace. However, this simply amends the legislation to reflect what employment tribunals have already decided in this case. So if a transfer involves the employer changing the location of its business or a part of it, dismissals due to that change of location will not usually be automatically unfair. Stay tuned, continue watching. Thank you so much. This is providing that the sole or principal reason for the dismissal is an ETO reason, and the dismissals are for redundancy. So if the reason for the dismissal is nothing to do with the transfer, and if the dismissal was not connected to the transfer, the usual unfair dismissal rules apply. If you watch this video, watch with the rest of the other videos, because this is a continuation. This may apply, for example, to dismissals for redundancy, misconduct, retirement, expiry of a fixed-term contract, and ill health. So an employer dismissing an employee in these circumstances should follow dismissal and disciplinary procedure as they should for any dismissal. You need to actually look into more detail about statutory dismissal and the disciplinary procedure in other parts of the United Kingdom. You can do so by visiting the internet and look at the information as they may be necessarily available. So it is automatically unfair to dismiss an employee for a reason connected with a transfer of undertakings unless the reason is an economic, technical, or organizational reason, e.g. or entailing changes in the workplace. So the dismissal may be by either the old employer or by the new employer. If the dismissal is for a reason connected with the transfer, which is an economic, technical, or organizational reason, e.g. or the dismissal is not automatically unfair. It may, however, still be ordinarily unfair for some other substantial reason. The usual rules about unfair dismissal will apply, taking into account the reason for the dismissal and whether the employer has followed proper procedures in dismissing the employee. Stay tuned, continue watching. If the dismissal is for a reason which is nothing to do with the transfer, for example, the employee has been dismissed for genuine gross misconduct, the usual rules about ordinary unfair dismissal will apply. You can look online in more details about claiming unfair dismissal as such. So whether an employee was dismissed for a genuine ETO reason or simply because of the transfer and a desire on the part of the new employer to vary the terms of the contract, it is a question of fact for the tribunal or the court to decide. Because of the uncertainty as to where possible liability for any dismissal may lie, employees should name both the former and the new employer on the ET1 form. If you are in any doubt as to how to advise an employee, if you are an advisor, you may be subject to a tube. You must whether your employee who may be an employee may be whether or not they can be subjected to tube, you must refer them to a specialist employment advisor. So we're looking at dismissal before a transfer takes place. Regulations say that contracts are transferred automatically where the original employer transferor employs the employees immediately before the transfer. A common problem that results from this is where a transferor dismisses one or more employees before the transfer. In an important case in this issue, dock workers were deliberately dismissed by the original employer and the new employer's request, and at the new employer's request, 1 hour before the transfer contract was signed. The House of Lords decided that the regulations are to be interpreted so as to include employees who would have been employed immediately before the transfer if they had not been unfairly dismissed for a reason connected with the transfer. In this case, the House of Lords reasoned that the dismissal were ineffective because they were connected with a relevant transfer. So the employees concerned were therefore able to claim unfair dismissal from the transferee because liability for the dismissal are transferred to the new employer. So the employer should use a dismissal procedure and the employee should appeal under the procedure if they can do so within the time limit for making a claim to the tribunal. You watch this material, watch with the rest of the video material. We have talked already about time limits. More about dismissal procedure in England and Wales and Scotland. This material applies to the United Kingdom. We have also provided definition of what United Kingdom is in the other material. So on the Employment Tribunal claim form, the ET1, the employee should put down the names of both the former employer, the transferor, and the new employer and employer, the transferee. So the employment should be taken against the employment tribunal will decide which employer the case should be taken against. So in case involving changes to service providers such as local authorities, there may be 3 possible respondents. In theory, an employee in these circumstances could make a straightforward redundancy claim against the original employer. However, this is not advisable. The employee would reach a tribunal deciding that the employer is not liable as the contract has been transferred. So by pursuing the action described in the previous paragraph, they can keep all options open. In the comment below, let me know what you are thinking. So look at qualifying period for claiming unfair dismissal. In England, Wales and Scotland, if an employee starts work on or after the 6th of April 2012, they will not qualify to claim unfair dismissal until they have worked for their employer for 2 years. We have discussed this condition previously. If the employee started work before the 6th of April 2012, they will qualify to claim unfair dismissal once they have worked for their employer for 1 year. In Northern Ireland, the 1 year qualifying period for unfair dismissal applies regardless of when the employee started work. In all cases, an employee would be able to make a claim for automatic unfair dismissal or for dismissal for a discriminatory reason, and these claims do not require the employee to have worked for any length of time. We talk about discrimination. To look at about identifying unfair dismissal and who can claim unfair dismissal. So look at employer liability information. The transferor, former employer, must inform the transferee, new employer, of certain information before the transfer takes place. This is called the employer liability information. There is more information about this in the Department for Business Innovation and Skills guidance available on gov.uk website at www.gov.uk. Stay tuned, continue watching. Let's look at employers' duty to consult and inform employees about transfer. So there is a duty upon both former and new employers to consult and inform the affected employees. If an employer intends to sell or otherwise transfer part of or all of a business, both the former employer and the new employer must consult with either the representatives of a recognized trade union, if there is one in the workplace, or representatives of the employees who have been elected by the affected employees. If there is no recognized trade union and there are no elected employees representative, the onus is on the employer to arrange for employees representative to be elected. If there are both elected employee representatives and representatives of a recognized trade union, the employer must consult the representatives of the trade union. The employer must tell the representatives the following: that the transfer is to take place, when the transfer is expected to take place, the reason for the transfer, all measures to be taken in relation to the employees by the transfer and the transferor, or the transferee and the transferor. This would include any plans or proposal which would affect the employees. The employers must ensure that all affected employees are consulted, including those on maternity leave or sick leave. A secondment: failure to consult an employee on sick leave may mean the employee has a potential disability discrimination claim and failure to consult an employee on maternity leave may mean the employee has a potential sex discrimination. Stay tuned, continue. So, if no representatives are elected within a reasonable time after the employer has invited affected employees to elect them, the employer must give each affected employee the same information about what the transfer plans are. Let us look at consultation on collective redundancy before the transfer. In England, Wales and Scotland from the 31st of January 2014, if there are to be collective redundancy, the transferee can choose to consult or start to consult transferring staff about collective redundancy before the transfer takes place. This is called pre-transfer consultation. The transferee will be able to do this only if the transferor agrees to it, the arrangement. So you can look more at collective redundancy. Let's also look at micro-employers' duties to consult and inform. In England, Wales and Scotland, in connection to the transfers which take place on or after the 31st of July 2014, a micro-employer can inform and consult directly with all the affected employees where there are no existing appropriate representatives. A micro-employer is an employer with fewer than 10 employees at the time when they are required to give information about the transfer. Let's look at other measures. If measures are proposed, the consultation must be about seeking the employee's agreement to the measures. Employers cannot just make changes first and then see if the employees agree. The measures proposed must be the definite plan or proposal which would not happen but for the transfer. If the employer rejects the representation of the employee representatives, the employer must give reason why they are rejecting their views. Let us look at compensation for affected employees if the employers do not consult or give full information. So if an employer fails to consult or fails to give representatives full information, the representatives can complain to an employment tribunal and ask for compensation for all affected employees. So the claim must be made to an employment tribunal within 3 months of the date of completion of the transfer. There is no requirement for the representative or affected employees to raise a grievance in this situation before the claim can be made to a tribunal. The maximum amount of compensation a tribunal can award is 13 weeks pay for each employee. Stay tuned, continue watching. The ETA, the EAT, Employment Appeal Tribunal, has ruled that the maximum should be awarded as the norm unless there are mitigating circumstances justifying making a lower award. And as you can see, this is important and valuable right for employees and advisors. If you are an advisor, then you must be careful to ensure that claims to the tribunal for a failure to consult are not missed. This should be included in the gathering of the material. So the regulation make it clear that both the former employer and the new employer are jointly and severally liable for these awards. Advisors, if you are one or otherwise, should therefore normally consider naming both parties in any employment tribunal claim. It is not necessary to wait for the transfer to take place before the representative or employee can make an employment tribunal claim. So if the compensation is not based on the maximum amount of weekly pay which applies to tribunal awards, but on the employee's actual week's pay. Neither is the award based on any loss. The award is intended to be punitive and to act as a deterrent to employers to stop them failing to consult with employees. So the employment tribunal can award maximum compensation even if consultation would have made no difference. The employer does not have to show that they have lost out financially for a claim of maximum compensation to succeed. You can check to find out more about the maximum amount of a week's pay for tribunal awards, more about the maximum amount of a week's pay for tribunal awards in Northern Ireland. Let us look at time scale of consultation. So the time scale of the consultation depends on the extent of the measures being proposed or taken. If large-scale redundancy are proposed, see the next paragraph as well. The regulation do not state a time scale, but only require that consultation be long enough to enable the employer to consult with all the representatives and or employees before the transfer takes place. So arguably, consultation should take place at least 28 days before the undertaking transfers, but there is no statutory time limit. If the employer does not consult affected employees, they can claim compensation. So in cases where there are large-scale redundancies, special rules apply. In the sense where it is proposed to make 100 or more employees redundant, in England, Wales and Scotland, consultation must take place at least 45 days, 90 days before the 6th of April 2013. Before the proposed dismissal. This means the law has been changed in favor of employer rather than in favor of employee. So in Northern Ireland, it is 90 days before the proposal dismissal. In all cases, the employer should follow a proper dismissal procedure. Where it is proposed to make between 20 to 99 employees redundant in England, Wales and Scotland, consultation must take place at about 30 days before the proposal dismissal. In Northern Ireland, it is 90 days before the proposed dismissal. In all dismissal procedure, in all cases, the employer should follow a proper dismissal procedure. You can look in fair detail the dismissal procedures in England, Wales, and in Northern Ireland of objecting to working for the new employer. Before a transfer takes place, an employee can object to working for the new employer. If they object, their contract will not be transferred to the new employer, and their employment will cease on the date of the business transfer. They will also not have been dismissed and so cannot claim redundancy, unfair dismissal or pay in lieu of notice or any other damages, unfair dismissal or pay in lieu of notice or any other damages, as there will have been no breach of contract. the contract would be transferred as having been refused, or as being frustrated, rather. So the High Court has held that an employee can object to a transfer after the date of the transfer if they did not initially know the identity of the transferee and they object promptly as soon as they find out. In such a case, the objection has a retrospective effect and prevents TUPE operating. So the objection must be a genuine refusal. For example, if the employee signs an objection in order to receive an a severance pay, but then works for the new employer, this is unlikely to be judged as a genuine refusal. The employee must also make the objection clear, and it must be made before the transfer has occurred. So if an employee has made a spontaneous off the cuff remark such as "I wouldn't work for him," this should not be taken as a refusal under the regulations. If an employer is attempting to evade their responsibilities under the regulations by quoting such a refusal, it should be pointed out that this would be in contravention of the intention of the European directive, and that is also known as TUPE. However, if the transfer involved or would involve a substantial detriment change in working conditions, the employee will be treated as dismissed and can therefore claim redundancy or unfair dismissal. Let's look at a situation after the transfer. Once the transfer has taken place, the employee should be given an up-to-date written statement of employment. This should be this should give the name of the new employer and confirm that the employees' terms and conditions of employment have not changed. The employee may also have received a P45. This does not mean that they are out of their job, but just that their tax records are being updated. Stay tuned, continue watching. You can look for further help within the gov.uk. So this information, the transfer of undertakings, is there online, like I said before. Thank you so much for your attending today, and I'll see you in the next material, which will be a continuation of this, and we'll come to the end of this segment involving employment as an infrastructure of working in the United Kingdom, in law and also in policy. And that's what we have been going through, because we have talked a lot already. So I needed to pinpoint a certain specific to kind of like connect with the rest of the other videos for the whole conversation to make a more integrated outlook in terms of law and policy here in the United Kingdom. And therefore what happened in the UK is similarly happening across the globe, including in Europe, America, and the rest of the continent. If, as I said in the beginning, in the opening, therefore let us continue with this exercise. Stay tuned as we chat. We end this video. Remember to subscribe to this channel, click like, click notification bell also, so that you don't miss the new videos. If you like it, if you don't like it, leave a comment below. If you like this material, if you don't like it, if you enjoy it, if you don't, let me know about it. There are people who might value it. If you don't value it, that is okay. If other people you know value it, help them to also watch and let me know. Thank you so much for your support, and I'll see you in the next one. Thank you. Bye bye.